Hey Rashee, I'm just doing a test right now.
Okie doke. Am I okay on sound?
Yep, yep, I can hear you.
Great. All right. Darren is going to join as a panelist also. He's going to introduce Nakia.
Okay.
I sent him a panelist link in email and then through WebEx as well. Hi, Nakia.
Of the government lawyer bedeviled us when I was there at the Attorney General's office years ago. Happens to still be quite an issue. So
well, now they have Erica.
That's right.
Who can help them sort it out.
It's funny how some of the same themes go on year after year.
Rashee, when you see it, are you seeing it as like the slide and then the numbers on the side? I'm trying to figure out.
Yeah, I think, are you able to put it in presentation mode? I think maybe it's in view. Yeah, perfect. Okay, looks like we've got about 40 attendees on right now. Do you want to give it another minute? Looks like a couple are coming in still.
Yeah, let's give everybody another minute
Okay.
or so. Well, you all control when it starts.
Yeah.
Are you
right.
speaking and then introducing Darren?
Sure.
Or no, I'm just asking.
What's that? I'm sorry.
Yeah. I guess for everyone on currently, this is legal ethics for government attorneys, and we'll get started in just about a minute. Okay, I see the attendee count is ticking up just a little bit. Looks like it's kind of leveling off. All right, Darren, if you'd like, you could get us started.
Sure. Well, welcome everybody. My name is Darren Sobin. I'm the Chief Programs Officer here at the DC Bar. Before that, I spent many years in the district government, about 10 years in the Attorney General's office for legal counsel division. And then after that is the executive director of the Board of Ethics and Government Accountability. And now I'm over at the bar. And so we look for opportunities, of course, to coordinate whenever we can. I am actually still on the board of BEGA as a board member. Ethics Week is something that was always very near and dear to me when we started, because it was an opportunity to bring all of our folks together for a seminal event each year and sort of all get on the same page when it comes to best practices and good ethics work. And of course, a lot of that has to do with how attorneys conduct themselves, government attorneys specifically. So we are very fortunate today to have one of our legal ethics counselors here at the DC Bar, Nakia Matthews, who works in the Regulation Counsel Department. Nakia started at the DC Bar in 2015 for the Pro Bono Center as an attorney, and then transitioned over to my group in Regulation Counsel as one of 4 legal ethics counselors. Now, our legal ethics counselors are part of the legal ethics program, which seeks to serve all 118,000 members of the DC Bar who reside in all 50 states and 84 countries. It is their job to provide guidance and advice and to draft opinions many of the same things that BEGA does for government employees. The DC Bar Legal Ethics Team does for attorneys who are admitted to the DC Bar. And so Nakia is going to talk to us today about the certain unique things that apply to government attorneys in her segment that ends Ethics Week, actually, called Legal Ethics for Government Attorneys. So thank you all for coming. Nakia, it's all yours.
Hello, everyone. Thank you, Darren, for that wonderful introduction. We always like to also plug the other regulation counsel programs, like Practice Management Advisory Service, which may not be applicable to some of you, but for those of you who are looking to maybe start your own practice when you leave government service, they're a wonderful service. They're a two-person team, and they are wonderful. Dan and Caitlin, they kind of help people set up their own practices. They come in and do audits and things of that nature. And so that's a wonderful service that's available, as well as we call them the Lawyer Assistance Program, or LAP for short. And they provide services, mental health services, and other services to both law students and lawyers who are members of the bar. And they have great working groups and like ADHD, lawyers who have ADHD or people who are returning to work after time off. That is definitely a free service that you would want to avail yourself of. Also, before we get into the presentation, there's also the dcbar.org, which has a lot of resources that are available to you, including all of the formal ethics opinions from the Legal Ethics Committee, as well as the rules themselves are available on the DC Bar website. So I will go to trying to go to the next page. Bit of a little technical difficulty. Here we go. So Rashee, I don't know if you want to talk about the resources that BEGA has online for other individuals.
Sure. Yeah, we've got a recently redesigned, pretty robust website that has advice. I mean, it has information on everything we do, from advice and training to enforcement. You can find all of our negotiated dispositions on there. If you'd like to take training, that's available there. If you want to just access some resources to refresh yourself quickly without having to talk to anyone else, you can find one-pagers on different issues such as the Hatch Act or outside employment. And yeah, there's a lot to be found there. And if you can't find it, you can always reach out to us at BEGA@dc.gov, and we're always happy to point you in the right direction or give you the advice you need.
It's also on the slide is the number for the Informal Ethics Guidance Helpline. So we're there Monday through Friday, 9 to 5. You can give us a call. We're usually able to provide answers on the spot. Sometimes we do consult as a group and have to get back to you, but we aim to be able to provide you kind of on the spot ethics guidance, because we understand that some things come up and you may need that sooner rather than later. There's also a process for getting formal ethics opinions from the larger ethics committee or chair letters. If you require that, you can read more about that on the website. We'd also like to point out that we're separate from the Office of Disciplinary Counsel. So our goal is we're kind of the preventative medicine, and disciplinary counsel is there to do investigation and enforcement of actions against DC lawyers who are alleged to have violated the rules. And the goal of LEP is to not get you to that point. So we always stress that we are a confidential helpline. The information that you give us, you can present it in a hypothetical, or you can give us as much or little information as you need. We do not share that information with disciplinary counsel. Okay, so the rules of professional conduct. A lot of people, I know when you go to a lot of conferences, they talk about the ABA rules. They are the law actually nowhere. The rules have to be adopted by a specific jurisdiction, though they do provide guidance. But DC is often very unique, and we differentiate or diverge from the ABA rules in many respects. So it's always important to make sure that you're looking at the DC rules of professional conduct, or if you're barred in other jurisdictions, make sure that you're looking at those specific rules and not just the ABA rules. The rules of professional conduct are rules of reason. So we always tell people when you give us a call, sometimes there's not a specific ethics opinion or a specific guidance that has already written guidance. And so we kind of have to talk through and work through issues, but we always come from a point of, which is stated in the scope of the rules, that the rules of professional conduct are rules of reason, and they should be interpreted with reference to the purposes of legal representation and of the law. And in that context, we also only give guidance from the rules. Sometimes there is a particular issue where we will have to send you to BEGA or your agency ethics officer, just to make sure that you're also getting kind of an understanding of whatever federal and local statutes or the substantive law that may also give specific ethical mandates. Okay, so we like to teach from hypotheticals, so I'm not the only one talking and lecturing. Like a law school exam, though, these are like the best answers. They may not be the answer, and they're written in a way to help us spark debate and conversation and interaction. So please feel free to, Rashee, I don't know if they can unmute themselves or they're supposed to put them in the chat, but feel free to engage and ask questions and interact.
I think it might not have an option to allow them to unmute. So definitely go ahead and put it in the chat, or if you raise your hand and you'd like to speak, then I think I can manually unmute you.
Okay. So the first typo, Laura works as an attorney advisor for the DC Department of General Services. She also has an accounting degree, but accounting is not tied to the work she performs for her agency. She would like to start a side business. Her two options are starting a tax service or an online boutique to sell handmade quilts. Which business can she start without running afoul of the DC rules of professional conduct? A, the online boutique. B, the tax service. C, and I should also say, if you could try to put your answers in the chat, that would help, just so I can, and Rashee, for some reason, I can't see the chat, but if you could kind of tell me what the
Yeah, I'll keep an eye on it.
majority
I don't see any answers yet.
So I'll go back. A, the online boutique. B, the tax service. C, both. And D, neither. Okay, I can actually see them.
Seeing some C's come in.
Yeah. I can see a message flash across the screen. I just can't see it all. But it looks like a lot of C's.
Mm-hmm.
Some A's. I'll give it another second or two.
Couple A's.
So the answer is C, both. And so if this were a call coming into the helpline, we would initially start to talk about Rule 5.7. So, in the gig era, a lot of people have side hustles or, like to do certain things like make pottery and things like that. Being a lawyer certainly doesn't prohibit you from doing that, just as certain precautions that you want to take, especially if it's something that may be specifically tied to what you're doing as a lawyer, which is typically difficult, maybe difficult for government attorneys, but certainly this is something that's come up, and so we wanted to make sure that it's highlighted. So the rule regarding law-related services, the real issue is really two specific things. One, is it distinct from the services that you provide as a lawyer? And two, making sure that if you control the entity that is providing the service, that you're taking those reasonable measures and steps to ensure that the client or the individual you're providing those services to doesn't believe or think that you're their lawyer. Now, certainly, if you're selling quilts, no one thinks that the quilt maker or the person on Etsy is representing them. But when you're dealing with something like tax services or anything that's really like law adjacent, you really want to make sure that you're taking steps to ensure that you have some type of, usually it probably would be better if it's written down, something that you can go over with the client or the customer so that they understand, yes, I'm a lawyer. Yeah, I mean, maybe running this tax service, but I'm not offering this as part of my law services. I'm not your lawyer. The rules of professional conduct don't apply. Most people want to hear about 1.6 confidentiality because they kind of start blurting things out. So that's what most people know. That's Law and Order on TV stuff, but you kind of want to make sure that you have a well-rounded, this is not an attorney-client relationship. This is I'm selling you a quilt or I'm doing your taxes. And this just talks more and further reiterates the importance when you're engaging in the law-related services of explaining to the client kind of the parameters. And again, this is probably more in line with when you're doing a tax service or lobbying or things like that, because there's just a lot of cross-pollination in those areas. Rashee?
Yeah, so if you were on the last session from 1 to 2 p.m., that was an entire hour on outside employment and outside activities. And this is the list of 10 things that Maurice had mentioned earlier. So you are able to have an outside job and you're able to do outside activities subject to certain limitations, such as it doesn't interfere with your ability to perform your job. You're not using government time or resources other than for official business. You're not directing or ordering subordinate employees to do outside work that you don't have some kind of financial or economic interest in the organization where you're working at that is competing with the government. That you are not capitalizing on your title or your official title or your position, that you are not sharing confidential, non-public information, those types of things. If you were on that last session, if it impairs your mental or physical capacity, such as you work at DC government during the day and you work somewhere else overnight, and then now you're too tired to work for your government job, that can be an issue as well. Or as an attorney in a representative capacity or as an agent for an outside entity involving any matter that they have before the district. So that's something you definitely want to check on.
Okay. So Hypo 2, Denise is an attorney advisor for the Office of the Inspector General. She volunteers at a Saturday morning legal clinic run by a local nonprofit provider. Under the DC rules, must Denise clear conflicts for each person she plans to see at the clinic? A, yes. B, no. C, it depends.
I've seen a couple B's come in. Now we're getting a little of everything. It depends.
The lawyer's favorite answer.
Mm-hmm. Yeah, we got a fair bit of it depends.
Okay. I'll give it another minute or two, or another minute. So the answer is B, no. And that's because DC has a special rule for those court annexed and nonprofit limited legal services providers, which is Rule 6.5, which says essentially that if you're providing legal services to a program that's either through the court or a nonprofit and it's a short-term provision of legal services, then you do not have to run a conflicts check. You can, and as Darren mentioned earlier, before I came to the DC proper, I was at the Pro Bono Center, and I actually ran our Saturday clinics. And so there are some people that do have their conflicts person on the phone or their computer there, and they're checking conflicts, but you operate under what's called a known conflict. So of course, if you're a DC government employee, you're not going to see anyone who has an issue where they're adverse to the DC government, usually also adverse to the federal government, where they're like seeking benefits, things of that nature. But as long as you don't know of a specific conflict that either you have or someone else in the office has, you're not required to run conflicts because of the 6.5 exception. Now, if you're going to take that particular case back to the office, if you decide that, hey, I need to do some more work on this and it may take longer than just a day, or maybe you want to provide representation in that specific matter, at that point of making that decision, then you would need to make sure that you are running a subsequent conflicts check. Always a plug for pro bono service. You have the DC Bar Pro Bono Center, which has a great network. I actually just talked to Erica Sillebauer, who is former ethics counsel at the DC Bar and now at OAG. And she's in the process of putting together a group to staff some of the Saturday clinics. And there are also the thousands of other great legal service providers in the district that you can use to be able to fulfill your pro bono requirement. It's not mandatory. There's no enforcement mechanism. It's aspirational. But the DC Bar members have always done a great job of doing pro bono service.
And this is kind of a recent addition to the conflicts of interest rule. Is I think it was passed in 2022, and this was an addition that added pro bono legal representation underneath the conflicts of interest rule. Does DC government set aside specific time for attorneys to do pro bono? I don't believe so. Not built into this to your regular work. You might want to check with your specific employer if they have a different policy for that. But as far as conflicts of interest, this new legislation made it so that DC government employees can provide legal representation in some proceedings if the matter does not involve a claim against the district. It's not in the district in a criminal proceeding, or the district doesn't have a substantial or direct interest in the matter.
Did you want to talk about, was this part of what you were talking about before? Sorry.
Oh yeah, sorry. I think, yeah, this is the same. So these are all of the pro bono legal representation rules under section 223A. So you'll see, which ones you're not allowed to do, but this was enacted to kind of help DC government employees have a chance to do some pro bono service.
So the next hypo, Kevin is a lawyer with the DC Office of Tax and Revenue. Kevin is considering opening an investigation into Eat Good Restaurants' compliance with its tax obligations. When Kevin tells Marty, his boss, Marty directed Kevin to open the investigation ASAP because he knows that the restaurant is corrupt. Marty further explained that he knows of the corruption because his cousin is a vendor of the restaurant and has told Marty stories about the owner's interactions with his employees. So should Kevin open the investigation based on Marty's instruction? A, yes, because Marty has already addressed conflicts and disclosures. B, no, Kevin should gently get Marty to assess whether he has a personal interest conflict that may require recusal. C, yes, because Marty's issues are not Kevin's problem. Kevin can do as instructed until he thinks instructions are clearly problematic.
Got some B's coming in. Sorry, one part that while the answers are coming in, one part that I missed on the pro bono legal representation part is that one section of the rule is that you are not receiving compensation for the legal representation. So it's specifically a carve out just for pro bono work, not for, so you can have another legal job on the side. Seeing mostly B's.
I think I'll give it another minute. So the answer is B, gently get Marty to reassess whether he has a personal interest conflict that may require recusal. And so the rule that I have pulled up is Rule 1.7b4, which is essentially the personal interest conflict. We also refer to it as the punch pulling. And so the question here really is does Marty's relationship with the third party, particularly his cousin, impact his ability to do his job for his client? You know, is he going to be so concerned about proving his cousin right that there must be something going on that's going to divert attention away from the objectives and the policies and the procedures that his client may want or have for this particular investigation. So Rule 1.7b4 essentially says, you shall not represent a client with respect to a matter if the lawyer's professional judgment on behalf of the client will be or reasonably may be adversely affected by the lawyer's responsibilities to or interest in a third party, here the cousin, or to the lawyer's own financial, business, property, or personal interest. This is not an absolute. This particular conflict can be cured. There's a two-pronged test set forth in 1.7c, which essentially says, you know, if you get the informed consent of the client, and informed consent is defined in our rules at 1.0e, and so it has to meet certain requirements. If you get the informed consent of the client and you kind of do a self-assessment, you reasonably believe that you can continue to provide diligent and competent representation, then essentially the conflict can be cured and you can move forward with the representation. I don't know about the practicalities of getting a waiver in government. Let me, Rashee, talk about that a little bit.
Yeah, this came up earlier in the week in one of our other sessions that it is extremely rare that as a government employee you'll get a conflict of interest waiver. I think in our discussion on Monday, it was I think one time in the last 10 years that we've seen it happen. So it's extremely rare. I wouldn't count on it.
And any position, does that cover the position as it relates to families and investigations?
Yeah, I believe so. So yeah, what part of under 1800.3H, you have a duty to act impartially. So if you know that you can't, then guess what? You probably shouldn't, right? So that would be a time to recuse. And we talked a little bit about the pro bono carve out for conflict of interest, but for actual conflict of interest, you should not be using your official position or title to attempt to influence the outcome of any particular matter that you know is likely to have a direct and predictable effect on your financial interests or the financial interests of a person closely affiliated with the employee. So I don't know if in this particular case, if their relationship is close enough where there is an actual financial conflict of interest, but it seems like it's getting more into that acting impartially. Would this employee be able to act impartially if he already has some outside knowledge of the situation prior to entering the investigation?
Yeah, I think our guidance would be if a call like this came into the helpline is to have Marty recuse himself, have someone else
Mhm.
just from the very beginning.
Yeah, it sounds like a best practice here.
Yeah, make the determinations, because if you get halfway in, it's always worse to try to course correct than to miss
Yeah.
the button at the beginning. Okay. Our next hypo, Warren is a lawyer for the Office of Administrative Hearings. He is mowing his lawn on Saturday morning when he hears a fight between his next door neighbors. Patrice is a lawyer in the domestic violence section of the DCOAG, and Rachel is a teacher. Patrice and her partner Rachel began arguing. As the argument moved outside, Patrice picked up a shoe and threw it in Rachel's direction. It flew past her head. The police were called and asked for a short statement from Warren. Under the rules of professional conduct, does Warren have a mandatory duty to report what Patrice did to the Office of Disciplinary Counsel? A, yes. B, no.
Seeing a lot of no's.
A lot of B, yeah. Either this was easy or you all are ethics experts. Um, I'll give it another minute. Okay, so the answer is B, no. I'm actually going to skip ahead to this slide because I think it makes more sense to start here. So the mandatory reporting rule in DC is Rule 8.3A, and it essentially says a lawyer who knows that another lawyer has committed a violation of the rules of professional conduct that raises a substantial question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the appropriate professional authority. So when we talk through this one, it's always, three prongs. No, which actual knowledge or inferred from the circumstances. Knowledge is defined also in the rules and the terminology section. And then we have a violation of the rules of professional conduct. And so that's where, I want to talk about 8.4b. 8.4 is kind of what we call the 24-hour rule. So whether you're in court or acting as a representative for an individual, or whether you're just, kind of yourself just walking down the street, these rules apply to you. And specifically 8.4, it is professional misconduct for a lawyer to commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. So whether or not throwing the sandal at the head, it's been a while since I've taken criminal law. Maybe it's apprehension of an imminent harm, or so maybe it's an assault. I don't know. But the second part is why we found that the answer was no. Does this go to the lawyer's honesty? Does it go to their trustworthiness or their fitness as a lawyer? That last part is usually highly debatable, but for at least for this particular hypo, the answer is no. So then we go back to, again, 8.3. While Warren may know that something has occurred, it doesn't seem that it's a violation of the rules of professional conduct. And so that second prong isn't there. And again, the third prong of that is even if it was a violation, does that violation raise a substantial question as to that lawyer's honesty, trustworthiness, or fitness? And so not every violation is going to reach those, or every issue or every concern that about another lawyer's behavior that a lawyer has engaged in will meet those three prongs. And we always say you can kind of argue yourself in or out of the rule, as you can with most rules or laws. But it's just something to think through. We also always, not that we think that lawyers are going to do this, but it is a rule for a reason. So whenever we talk about mandatory reporting, we also bring up 8.4G and Legal Ethics Opinion 220, which deal with threats to file disciplinary charges. So if you think an opposing counsel or a lawyer for a witness has engaged in behavior that may rise to the level of an 8.4 mandatory reporting, it's kind of then report it. It's can't kind of sway that, stand in between that line. And if you do, because some people are not trying to be vexatious or argumentative or with their opposing counsel. And so there's kind of like I don't want to report them, but I also want the issue to be addressed. You have to make sure that you're doing it in a manner that doesn't violate 8.4G. Our guidance is always, if you believe that the lawyer, you can kind of say, hey, did you understand that when you did this, this was an issue? That's one way to approach it. But if that person is just naturally combative and they're going to kind of say, oh, are you doing this and violate? Because more often than not, people are aware when they're crossing the line, they are aware of the 8.4G rule. If that's the only one that they're aware of, you kind of just want to make sure that you're threading that needle as best you can.
Now, as far as BEGA is concerned, under 1800.3M, employees shall adhere to all federal, state, and local laws and regulations. So that would mean a case disposition, not just the accusation. And I think that, if I'm remembering right, that may be the same as under Chapter 16 in the DPM. That I don't think that you'll see a lot of agencies taking employment action even without a disposition, rather than just the accusation, but I might be wrong on that. But at this point, it would be a little bit too premature to make that report to BEGA, because there's not yet an ethics violation.
And so for those of you who are seeking CLE credit, the CLE code is on the screen. It is EL82, E as in Edward, L as in Larry, 82. I'll give you about a minute or two to write it down. We will also say it again at the end of the session.
And I will also, if you are seeking CLE credit, we have an evaluation. It's not actually open yet. It'll be open at 3:15 once the session is over. But you are asked to please do the evaluation if you're seeking credit. And if you're not seeking credit, please do the evaluation too, because it helps with programming.
Okay. Did everyone have sufficient time? I'll go back, or I think I may have mistakenly hit the next button. Okay. So same facts, but this time assume that Warren is also a lawyer at DCOAG, the same agency as Patrice. So remember, Patrice was arguing with her partner, threw a sandal past her head. Police were called. Should this change Warren's analysis about reporting to ODC and or OAG? A, no, because Warren still has no actual knowledge of misconduct. B, yes, because Warren now needs to take into account the organizational interests of OAG.
Seeing mostly A's. So in the last scenario, he worked at a different agency. He was at OAH, I think. Yeah. Okay.
Yes. Mm-hmm.
And so now they're coworkers.
So a lot of A's.
Mostly A's.
I'll give everyone another minute or so. So the answer is B. Yes, because Warren now needs to take into account the organizational interests of OAG. So this rule, Rule 113, is the organization as client. And it essentially has 3 prongs. I'm not going to read it just straight out because you have it on your screen, but the 3 prongs kind of, is there an officer or employee? And here we have Patricia, acting in violation of a legal obligation. So employee acting in violation of a legal obligation or law. 2, which can be imputed to the organization. 3, and cause harm. So because Warren needs to make that analysis, it's not the same situation as, should a straight report to ODC. And especially because he's at the particular agency, that agency theoretically is his client. So 1.6K in the DC rule says the client of the agency lawyer is the agency unless some other specific law says something to the contrary or different. So acting on that belief that, Warren is the agency, is the lawyer for his agency, and therefore his client is OAG, and Patricia is in the office of overseeing domestic violence prosecutions, that's something that has to be taken into account. And so the analysis does change in this situation. The next question, to whom should Warren make his report? A, BEGA, B, OAG, Human Resources, C, Warren Supervising Attorney, D, OIG. Steve?
So, I think some supervisor, some A's, some B's, some C's.
Mostly C's. Okay. Okay, I'll give it another minute or so. And the answer is C, Warren Supervising Attorney. So in part, this goes back to Rule 113. And 113 essentially is a report up, not report out. And that's one of the rules that deviates from the ABA model rules, because they actually have a provision that would allow you to report out of the particular entity or agency, where DC says, no, you can only report up, and kind of that's where the buck stops. So Warren would need to go to his supervising attorney and bring it to their attention, and they would be able to make the call whether or not it should actually be reported. When we look at Rule 5.2, which is the subordinate lawyer rule, it says that a lawyer is bound by the rules of professional conduct, notwithstanding the lawyer acted at the direction of another person. But it also says in B, a subordinate lawyer does not violate the rules of professional conduct if the lawyer acts in accordance with the supervisory lawyer's reasonable resolution of an arguable question of professional duty. So in some ways, it provides a limited safe harbor for Warren or for any lawyer who brings something to their supervisor's attention and says, hey, we need to discuss this. I may feel one way, the supervisor may feel another way. If the question is arguable and you have to go with the decision of the supervising attorney, 5.2 provides some cover to that subordinate lawyer. The other reporting considerations is also 1.6, and as I mentioned earlier, 113, is a report up and not report out, and that's because 1.6 client confidentiality is sacrosanct in DC, and so it's kind of built into 113 as a mechanism of protection for the organizational client, where 1.6 is the protection usually for the individual client. Rashee, I didn't know if you want to talk about centralized reporting within agencies. If your agency doesn't have this, is probably, we always say best practice, so that there's one person to vet these issues, one person if you need to get the consent of the client, because the mandatory reporting under 8.3, under 8.3, sorry, does have the stopgap of unless it would require you to divulge 1.6 client information. So if you have that centralized reporting within a particular entity or agency, all of that information, all of that could be vetted out through one system.
Yeah, and again, from our perspective, it may still be a little too premature. This likely should be handled within the agency.
So, Larry left his attorney position at the DC Department of Insurance, Securities, and Banking, that's a mouthful, DISB, 14 months ago to start a small firm. A prospective client would like to hire Larry's firm and possibly Larry to represent him in an administrative proceeding resulting from a DISB investigation. The investigation took place while Larry was at DISB, but he did not directly work in it. Under the rules of professional conduct, can Larry or his firm represent the client? A, yes, because it's been over a year since Larry left. B, yes, because you can utilize a screen which cures everything. C, no, because this has the appearance of impropriety. And D, maybe.
Let's see, we've got some C's and some D's.
A lot of C's and D's. So I'll give it another minute. Okay, so the answer is D, maybe. And in this case, I'll actually go back and kind of go through the answer. So yes, it's been over a year since Larry left. So the rules of professional conduct don't actually have a timing requirement. Whether it's been 6 months or 6 years, you still have to do the analysis, or we encourage you under the rules of professional conduct to still do the analysis. B, yes, because you can utilize a screen which cures everything. So we'll see in Rule 1.11, you can, in some instances, utilize a screen, but there's also a second part to that, which is that, the person can't be apportioned any fee from that particular representation. So technically, the screen itself doesn't cure everything. You would also have to make sure you're meeting the second prong of that requirement. No, because this has the appearance of impropriety. We'll talk a little bit more about the standard going forward. So let me pull up Rule 111. It's a favorite of ours here at the DC Bar. A lawyer shall not accept other employment in connection with a matter which is the same as or substantially related to a matter in which the lawyer participated personally and substantially as a public officer or employee. And then it talks about the different roles. C says B shall not apply if the person personally disqualified lawyer is timely screened from any form of participation in the matter and from sharing in any fees resulting therefrom, which I talked about earlier. So personally, participated personally and substantially is always the area of contention that results in the very long calls. Because rightfully so, we do have some legal ethics opinions that talk about it, but it's also something that needs to be talked about and fleshed out, because you could personally and substantially participate on something just because you were involved in one meeting. And so maybe you were in that case strategy meeting where you kind of set forth the trajectory of the case, or maybe, you were instrumental in that motion for summary judgment or the motion to dismiss or whatever, and that is gonna garner the participated personally substantially. But you could have also sat in on case meetings, case rounds for a year or two, and even though you were maybe at all of those meetings or some of them, you really didn't personally and substantially participate in the case. Maybe you never said anything, kind of zoned out and were thinking about what you need to get from the grocery store. Maybe one or two times you did say something, but it wasn't of consequence. And so we really like to highlight two things. Usually when you look at comment 3, it talks about the making of rules of general applicability. So usually in that particular instance, if you're involved in the rulemaking, it's not a matter, it doesn't involve parties. And so that's generally going to exempt you from the 1.11 analysis of the personally substantially participated. But we always encourage looking at the ethics opinions, looking at the particular case law. 111 is a long rule for a reason. There are a lot of comments, and there's, unlike many other rules, there's a lot of case law that's mentioned in those particular comments to kind of help weed through the analysis.
It ties right into our post-employment rules, which are also extremely fact-specific. And once you separate from district government, you have post-employment counseling from BEGA available for the rest of your life. So if you come into an issue where you need it again, or you need to analyze the issues of, it's like say you're 2 or 3 jobs out of DC government, but you're working on a matter that may still involve DC government, you can always come back to us and we can help you talk through that again and give you further advice. Now, as you may know, there are three main areas in post-employment. First is the cooling off period, which is 1 year. And that is no contact with your former agency with the intent to influence them. So that means, if you need to get your tax forms from them, or you need some employment verification from HR, that kind of thing is okay, but not to intend to influence them. And the 2-year prohibition is no acting as a representative in a matter that you had official responsibility for when you were a district government employee. So let's say you supervised somebody who had a matter that was not, maybe you weren't working on it personally and substantially, you weren't working on it extremely closely, but you supervised that person, that still comes under your purview. So no giving behind the scenes advice to your new employer regarding a matter that you participated personally and substantially in as a district government employee for 2 years. And finally is the permanent prohibition. And I feel like the permanent prohibition is actually probably for lawyers, it's more easy to understand, because you know that you can't sit on both sides of the same table, because then you're directly in violation of legal ethics, right? So no acting as a representative in or having communications on a matter that you participated in personally and substantially as a district government employee. And really, for the most part, and I'm sure there's other circumstances where it wouldn't be the case, but you can't be the prosecution and the defense. You can't be the plaintiff and the defendant. So that one is probably a little more clear, unless it's something like you were working on a deal or some kind of contract that the government had during that time. But again, you always have counseling from us for life on those issues. If it's like a real specific thing and just need to talk through it with someone, please contact us. We're always happy to do that.
And I'll just point out that this is another way in which the DC rules deviate from the ABA rules. So there's no waiver. Whereas in the ABA rules and in some other jurisdictions, they do allow you to go to the government agency and ask for a waiver for personal and substantial participation. But it seems like even if that were okay under the DC rules, BEGA has said that that's not acceptable.
Yeah, correct.
So I will give the CLE number. We're at the end. All of the hypos are done and over. If there are any questions or concerns or anything anyone wants to raise in the chat, but I'll go ahead and give the CLE code again, which is E as in Edward, L as in Larry, 82. E as in Edward, L as in Larry, 82. And again, the informal ethics guidance information is on the screen. You can also send us an email, but more likely than not, we will either ask you to give us a call or call you, because usually these things kind of have to be talked through. But that is a way to reach us.
Okay, and again, I'm putting in the chat the evaluation. So if you'd like to get your 1.0 CLE ethics and professionalism credits, please complete that evaluation. Please complete it regardless. The feedback is always useful. And that will open in 6 minutes at 3:15. So if you want to click on it now, you can have the tab open and you can refresh it a little bit later. That link will remain open until 5 p.m. on Tuesday, the 22nd. So please just have your evaluation done by that time. And within 7 to 10 working days after the 22nd, you'll receive an email with your CLE certificate.
Darren, did you want to say anything, or I have on my screen?
What an outstanding.
I
really appreciate both you, Nakia, and Rashee, because the interplay between government ethics and legal ethics really can be daunting. And I think the biggest takeaway from today is you have Nakia to call at the DC bar, and you have Rashee to call at BEGA. If you have any questions about this. When we started BEGA, I actually fashioned the advice giving function after what they were doing at the DC bar already, because I just thought it was so important that lawyers and government employees had a place to go immediately, like before they made that decision, to get information and guidance. Now, luckily at BEGA, we can give what we call safe harbor advice. DC bar, not quite there yet. The court has final say on what safe harbor advice is, but Nakia and her team certainly rely on long-standing precedent when they give advice out. And so I think I can honestly say if Nakia and her team say it's okay, it's probably okay. So thank you, guys. Enjoy the rest of your Friday.
Yeah, one last little note. There is an Ethics Week happy hour from 5 to 6 at the Lincoln Restaurant. It's at 1110 Vermont Avenue Northwest, which is basically around the corner from our office. And we would love to see you if you are able to come on out.
I'll be down there soon.
Thanks, guys.
Thanks, everyone.